Hey everybody, there is an update in the H3H3 case, the Triller Fight Club versus TED Entertainment case, but this is the one that was filed in the Superior Court of California. This was a case involving plaintiffs' allegations that defendants published 4 videos containing false, misleading, and malicious allegations concerning Triller, the Triller app, and Ryan Kavanaugh. Defendants are alleged to have encouraged their fans to leave 1-star reviews of the app. The court grants defendants special motion to strike plaintiff's first amended complaint. The special motion to strike is also known as an anti-SLAPP motion, a strategic lawsuit against public participation, and the anti version of that, the motion to get rid of the SLAPP. And so the court is granting H3H3's motion to dismiss, basically. Special motion to strike. It's not a motion to dismiss, but it effectively works like that. The statements at issue are, 1, statements concerning Ryan Kavanaugh, that Mr. Kavanaugh runs a Ponzi scheme, that defendants misrepresented an article in Variety magazine, that Mr. Kavanaugh bears a physical resemblance to Harvey Weinstein, that Mr. Kavanaugh sued defendants. 2, statements by Reddit users, quote, "Take down Triller, let's all rate Triller a 1 on the App Store. Foot soldiers, time to bank down Triller app, called by the king himself. Foot soldiers assemble, tank the Triller app, we can do better than this." An image shared by a user. "Triller went down 0.1 stars in the App Store. Keep up the honest reviews, foot soldiers." 3, statements concerning Triller and the Triller app. That Triller falsely represented that comedian Kevin Hart uses the app. That the app is flipped. "Yo Triller, my thing is flipped," comment originally made by Mr. Beck as he was creating a video using the Triller app. And I think they're referring to the video being flipped. Quote, "So I've been having fun looking up Triller. Like if you go to the App Store, I have them 1 star, by the way, just because I didn't have a positive experience. Yeah, but people should judge for themselves. Go download the app and leave a review. I'll be checking in on the Triller reviews. Try the app, see how it goes, and give it 1 star or more. 1 or more stars. Some amount of stars between 1 star and maybe 5 stars. Download Triller and rate it 1 star or more. That's what I did. We do not condone and we do not encourage troll reviews like this one." Once a defendant makes a basic showing that the plaintiff's complaint arises from constitutionally protected petitioning or free speech activity, then the burden shifts to plaintiff to establish, with admissible evidence, a probability that plaintiff will prevail on the claims challenged by the anti-SLAPP motion. The court does not weigh evidence or resolve conflicting factual claims. Its inquiry is limited to whether the plaintiff has stated a legally sufficient claim and made a prima facie or basic factual showing sufficient to sustain a favorable judgment. It accepts the plaintiff's evidence as true and evaluates the defendant's showing only to determine if it defeats the plaintiff's claim as a matter of law. Speculative inferences not supported by the evidence proffered need not be considered. So then the court starts in on the claims. The first claim is an underlying defamation and incitement claim. Remember, incitement is incitement to imminent lawless action. For plaintiff to show a likelihood of success on the causes of action for interference with current and prospective economic relationships and for violation of California's Business and Profession Code, plaintiff must show a likelihood of success that defendant's statements made on the podcast were defamatory or designed to incite. The elements of a defamation claim are 1, a publication, that is 2, false, 3, defamatory, 4, unprivileged, and 5, has a natural tendency to injure or cause special damage. The sine qua non of recovery for defamation is the existence of falsehood. Because the statement must contain a provable falsehood, courts distinguish between statements of fact and statements of opinion for purposes of defamation liability. Although statements of fact may be actionable as libel, statements of opinion are constitutionally protected. That does not mean that statements of opinion enjoy blanket protection. On the contrary, where an expression of opinion implies a false assertion of fact, the opinion can constitute actionable defamation. To determine whether a statement is actionable fact or non-actionable opinion, courts use a totality of the circumstances test of whether the statement in question communicates or implies a provably false statement of fact. Plaintiff has provided evidence that negative reviews were left in the Apple and Google App Stores using similar language as the podcasts at issue to show that defendants directed their fans to commit wrongful conduct. That evidence, however, is insufficient to show a likelihood of success on the merits for incitement, because while they provide evidence of negative reviews, they do not put forth sufficient evidence to establish defendant-directed or ratified tortious activity or wrongful activity. Defendant states in the podcast that fans should not leave fake reviews and condemns such behavior, while plaintiff argues Mr. Klein's demeanor communicates something more sinister. The evidence put forth does not show that Mr. Klein authorized or ratified specific tortious or wrongful activity. Plaintiff does not provide evidence defendant's statements were false or not opinion. In this context, the court finds the language used by Mr. Klein is more akin to parody, hyperbole, and primarily statements of opinion. Even if Mr. Klein's statements directing H3 fans to download and try Triller's app were not genuine, there simply does not lie a cause of action for defamation. Do as I do, not as I say, is not an assertion that can be proven as fact or opinion. In the context of defamation, plaintiff has not met its burden of showing a probability of success on the merits. Statements concerning whether Triller falsely represented that comedian Kevin Hart uses the app is a statement that can be shown to be true or false. Defendants have put forth evidence to support their basic showing that this statement was true at the time the podcasts aired. Despite not having a presence on the Triller app, the description of the Triller app stated millions of users have made Triller videos along with stars like Kevin Hart. The plaintiff has not put forth evidence to meet its burden of showing a likelihood of success on the merits that this particular statement was false, so they didn't show that Kevin Hart actually did use the app. A statement concerning the app was flipped is also a statement that can be true or false. And I think this means the video was flipped. I don't mean that they flipped it like you flip a house. Defendants have put forth evidence that this was a statement originally made by Mr. Beck while he was trying to record using the Triller app. Mr. Beck observed that the app had flipped the camera. Plaintiffs provide evidence that the app had an inversion problem relating to camera functions on certain iOS devices. Thus, because it contains an assertion of fact, it is non-actionable as defamation because plaintiff must show the statement is false. Plaintiff has failed to provide evidence to meet its burden of showing a likelihood of success on the merits of this statement. The remaining statements were posted to the H3 subreddit website, which identified itself as a social networking site, Reddit, and permitted users to create their own profile and post information on various forums. No evidence is offered to support the contention that the H3 podcast, Ethan Klein, Ela Klein, or Teddy Fresh created those comments. As to the comments made by third-party Reddit users, defendants cannot be held liable under Section 230 of the Communications Decency Act, which provides, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So there's another example of the Communications Decency Act being used for the immunity of the host. Plaintiff Triller cannot successfully assert a cause of action for statements concerning Mr. Kavanaugh. In defamation actions, the First Amendment also requires that the statement on which the claim is based must specifically refer to or be of and concerning the plaintiff in some way. Here, insofar as any statement is of and concerning Mr. Kavanaugh, those statements do not show a likelihood of success on the merits because Mr. Kavanaugh is not a plaintiff in this case. Plaintiff has put forth no evidence nor argument that Mr. Kavanaugh and Triller are known generally as one and the same. On to the intentional interference with contractual relations claim. The elements which a plaintiff must plead to state a cause of action for intentional interference with contractual relations are: 1. A valid contract between plaintiff and a third party, not the defendant. 2. Defendant's knowledge of this contract. 3. Defendant's intentional acts designed to induce a breach or disruption of the contractual relationship. 4. An actual breach or disruption of that contractual relationship. And 5. Resulting damage. Plaintiff has submitted evidence stating that The thousands of one-star reviews parroting defendants' allegations have had a detrimental effect on the app. According to plaintiffs' internal analysis of the damage caused by defendants' conduct, the thousands of one-star reviews parroting defendants' allegations have 1. Depressed the overall rating of the app, and 2. Depressed the conversion rate, or the percentage of consumers who choose to download the app after viewing it in the Apple App Store or Google Play Store. Now, I had no idea what this Triller app was, but apparently it's supposed to be some kind of competitor to TikTok. The Blatz Declaration states because Triller expends significant time and resources on its marketing campaigns, the depressed overall rating and the depressed conversion rate have caused and are continuing to cause Triller significant harm and millions of dollars in damages. However, in the declaration of Darren M. Traub, filed in support of plaintiffs' supplemental evidence, it states Triller has incurred approximately $927,000 in increased conversion costs as a direct result of defendants' conduct. Triller has additionally incurred approximately $615,000 to mitigate the damage caused by defendants' conduct. I mean, I guess I would have to see the rest of that declaration, but those sound like extremely conclusory statements. That means that they spent over $1.5 million to mitigate the damage caused by their own actions and the H3 podcast talking about it, unless they can prove defamation or any of these other claims. Finally, plaintiff states defendants' actions have caused additional damages, including reputational damages and goodwill damages, and Triller is not yet able to quantify those damages. A cause of action for intentional interference with contractual relations requires the plaintiff to provide evidence of a valid contract between itself and a third party, says the court. At the November 19th hearing, counsel for plaintiff explained the contractual relationship in each of these causes of action is between Triller and either actual users of the app or prospective users of the app, depending on whether the cause of action is regarding actual economic relations or prospective economic relations. But at all times, we are arguing that defendants are interfering with a relationship between Triller and the users of the app. That's the source of Triller's profits. Were the court to consider and credit all of plaintiff's evidence, it still does not find plaintiff has made a basic showing of an identifiable existing contract between plaintiff and a third party. Plaintiff does not meet its burden by merely stating that defendant's conduct disrupted current app users. The court is once again left to speculate as to the identity of the existing economic relationship at issue. The court is also left to query Triller's business model and whether app users pay Triller for the use of the app. Therefore, plaintiff has failed to meet its burden to specifically identify the contractual relationships that were disrupted by defendant's actions. Causation is the final element of an intentional interference cause of action. Here, plaintiff must prove defendant's conduct was a substantial factor in causing harm. The court is left to speculate as to the factors at play in app user behavior and what variables contribute to an existing app user's decision to stop using an app. Plaintiff has provided a number of possible reasons why app users may have left the Triller app other than defendant's actions. For example, plaintiff acknowledges that some users of the Apple iPhone may have experienced an inverted camera, frustrating the user's ability to record content. Numerous reviews provided by plaintiff in Exhibit A make reference to an inverted or flipped camera function. So this is evidence that Triller provided is now being used against Triller by the judge. Plaintiff's evidence of one-star reviews also demonstrates user dissatisfaction with the design and content of the app. For instance, one user left a review stating, "I downloaded this app and immediately I started getting emails saying my accounts have been compromised and my passwords have been stolen. I found out many other users have this same issue. The owner clearly knows nothing about running a business or app." Another review example was from a user who stated, "Basically just a terrible wannabe version of TikTok, basically just used for promotion of brands or celebrities. The content is extremely boring. Do not download if you still want brain cells." These reviews exemplify the difficulty for the court in discerning causation. The court does not speculate as to other potential reasons an app user may have left plaintiff's platform, and the court does not weigh the evidence presented. The court merely points out the speculative nature of plaintiff's damage claim and its failure to make a minimal showing on the causal link. Additionally, in reliance upon conversion costs, plaintiff appears to assert that conversion costs are a result of the expense of advertising to attract new users. If these costs are associated with finding new users, case law states a relationship to a class of yet unknown patrons cannot be characterized as an economic relationship. In failing to identify existing app users and their contracts with the Triller app, and in reliance upon damages sustained as a result of increased conversion costs, the court finds plaintiff has failed to demonstrate causation. Accordingly, the court finds plaintiff has not established that there is a probability it will prevail on the intentional interference with contractual relations claim. On to the intentional interference with prospective economic relations claim. This has 5 elements. They're similar to the above. This cause of action requires plaintiff to identify an economic relationship between plaintiff and a third party that probably would have resulted in an economic benefit to plaintiff. Here, plaintiff identifies the third party to be prospective users of the app. The court once again finds plaintiff does not and cannot identify a third party, as those viewing the app in the App Store are unknown potential users of the platform. Once again, the court queries as to if there are other reasons why a prospective app user would choose not to download an app other than the existence of a number of 1-star reviews. For example, do app users make comparisons between different platforms? Plaintiff's evidence also points to reviews favoring TikTok, the dominant social media platform with the majority of current market share. This observation of the content of some of the reviews submitted by plaintiff is meant to illustrate the challenge in proving causation under the facts of this case. So the court comes to a similar conclusion on the prospective economic relations claim. Negligent interference with contractual relations. Plaintiff cannot show a probability of a claim for negligent interference with existing economic relationships because California does not recognize such a cause of action. Negligent interference with prospective economic relationships is similar to the above, but the defendant must have failed to act with reasonable care. As discussed, plaintiff's evidence only shows 1-star app reviews similar in language to that of the podcasts. This evidence does not make the required showing of the existence of economic relationships between plaintiffs and third parties. Here, again, the court is left to assume Triller's business model, revenue streams, and what relationships have been disrupted. The court does not find plaintiff has made a basic case there. Violation of California's Business and Professions Code, which prohibits unlawful, unfair, or fraudulent business acts or practices. Virtually any law or regulation, federal or state, statutory or common law, can serve as a predicate for this section's unlawful violation. A fraudulent business practice is likely to deceive the public. It's unfair if it violates established public policy or is immoral, unethical, or oppressive, or unscrupulous, and causes injury to consumers which outweigh its benefits. The determination whether a business practice is unfair involves an examination of that practice's impact on its alleged victim, balanced against the reasons, justifications, and motives of the alleged wrongdoer. In brief, the court must consider the utility of the defendant's conduct against the gravity of harm to the alleged victim. Plaintiff's claim for violation of this section stem from the underlying defamation, incitement, and extortion claims and common law claims. The plaintiff fails to meet its burden of showing a probability of success because the statements concerning Mr. Kavanaugh are not of and concerning Triller. H3 cannot be held liable for statements made on the H3 subreddit by Reddit users. Statements imploring fans to download and try the app without more do not establish incitement because no facts show defendants authorized or ratified such conduct. Statements concerning Triller and the Triller app were demonstratable fact or opinion. Accordingly, plaintiff likewise fails to state a probability of success for violation of California's Business and Professions Code. Plaintiff claims that the statements were illegal because it was part of a larger scheme to extort Fight Club and harm Triller in violation of the law. However, plaintiff has failed to carry its burden of offering evidence. Plaintiff cites to the facts of the Flatley case, where an attorney admitted to sending a letter to a defendant threatening public disclosure of an assault unless the parties settled for $100 million. Plaintiff here has not alleged nor offered any evidence to show that defendant gave them an ultimatum to settle or face threat of public disclosure like in Flatley. Plaintiff offers 2 declarations and 2 exhibits showing that some of the negative comments regarding the app used similar language to the podcast at issue. The court is left to surmise the additional elements for extortion from this evidence. The second prong for an anti-SLAPP analysis places the burden of proof upon plaintiff to submit admissible evidence to show a probability of success. Negative reviews, along with statements from the podcast, do not meet the minimum requirement to show probability of success. Plaintiff fails to state a probability of success. For these reasons, defendant's special motion to strike is hereby granted, and plaintiff requested an opportunity to amend its complaint, and the court denies plaintiff's request. So that should be the end of the state court defamation, etc. claims from Triller, which is good. But we're still waiting for the hearing on the motion to dismiss the federal copyright claims, which I believe that hearing is coming up in April. So I guess we have to wait a few more months to find out what's going to happen there. Hopefully H3 prevails there. I'll have an update when they do. Thanks for bearing with me on that. That was long, and I look forward to bringing you an update on the next one. Love you all. Have a great one. Bye. Thanks for watching. Special thanks to our top supporters in January: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, NotMike, ShadowTycho, Earthbound Star, TechTechPotato, Eric Tams, PureMagma, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsus.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week and a happy new year. I love you all. Bye.